talk to you about who gets your stuff when you die. Another title for this speech would be 14 Secrets to the 2 Most Important Things in Your Life, Everyone You Love and Everything You Own. Years ago, I was working with a business coach and we were trying to come up with a tagline for our business. And he had me come up with my 6 favorite clients. And then we looked at those clients and we tried to decide what they had in common. And what we found is they had in common the same thing that you and I have in common, which is that we want to protect everyone we love, and that includes ourselves. We also want to protect everything we own and make sure that it goes to the people that we want it to go to. So another title for this speech would be How to Protect Your Assets Without Having to Give Up Control. And actually I use this as an alternate title in a lot of my speeches because one of the most important things to people is that they maintain control as long as possible. And the sooner you plan, the more control you can maintain over time. So if you plan while you're still competent, know who your family is, know what's going on, you have a lot more control than if you wait until you're not able to make your own decisions. So what you're going to discover is ways to promote family harmony, how to leave a legacy, so how to leave your assets behind in a way that they don't ruin people, how to protect yourself if you ever need care, and how to obtain peace of mind that you've done the best possible job putting together a plan. This is for you if you're worried about your children getting along after you're gone. Now, I don't have a magic wand. I can't make it where they get along if they don't get along already, but we can at least make it where we don't make it worse. And I can give you advice on how to make sure that you're not setting your children up to have conflict. If you're worried who's going to take care of you in the event you need care, and that's actually one of the harder things to think about and talk about because we all know we're going to die someday. But a harder question is, if you became incompetent, if you were unable to take care of yourself, who do you trust to take care of you? If you're sick about worrying about your family in general, and if you're confused by conflicting advice. So nowadays we can go on the internet and we can find advice on absolutely everything. But how do we know it's good advice? How do we know it actually applies in our situation? One of the things that's unique about the United States is every state has different laws. So if you find an answer that's correct in another state, it may not be correct in your state. And so it's important to make sure you get the correct advice. So imagine having the peace of mind knowing your family's going to get along after you're gone, or at least the documents that you prepared haven't made the family situation worse, knowing you're going to be taken care of if it's needed, and having a plan customized to your unique family situation because every family is different. One of the things I try to mention in every speech that I give is most families are dysfunctional. Now, some of you are lucky enough that I have to get into cousins or second cousins before we find the dysfunction, but for a lot of us, it's closer to home. So a little bit about me and the firm. We've helped over 6,000 families protect the assets that they leave to their loved ones from divorce, creditors, and lawsuits. We've also helped over 300 families implement the plans that we've designed, and over 1,200 families implement the plans that other attorneys have designed. And the reason why that's significant for you is estate planning is kind of depressing because we're talking about who gets your stuff when you die. So because of that, you're going to want to put together a plan, put it on the shelf, and forget about it. But what's important to you is that you're taken care of if something happens and your family is taken care of if something happens. And because we've walked alongside families in situations where there's been a loss of a loved one, we know how to make it run as smoothly as possible for you and your family. Our firm is unique in that we do estate planning and elder law. So estate planning is what we're going to be talking about mainly today. Estate planning is the who gets your stuff when you die. Elder law is Medicaid, veterans benefits, special needs. And there's a couple slides in here where we'll cover a little bit about those. But most firms only do one or the other. And so a lot of times those firms don't spot issues that need to be covered in your plan. So we meet with our clients every 3 years. One of the reasons why we do that is to check on your health as things go along. And if it gets to the point where you need to protect assets in case you go to the nursing home, we can have a conversation about that. So our firm belongs to a lot of professional organizations. So you get the experience of not only the 4 attorneys in our office, but you also get the experience of 3,000 attorneys nationwide. And we can learn from things that happen with their clients. Let me give you an example. There was an attorney up north, had a client who was in a car wreck. She ended up in a coma. She was in the hospital for a number of months. Her son took over and started handling her finances for her. He did an excellent job taking care of her money. And when she got better, she went to her son and she said, "Thank you for doing such a good job taking care of my money. Now that I'm out of the hospital and feeling better, I'd like to take back over. And her son said, Mom, I really like being in charge. And I'm a little concerned that if I let you be in charge, you're going to give more money to my sister than to me. And so this poor lady ended up in court fighting over control of her trust. So in our documents, we actually have language in the event that happens, where somebody else takes over in your trust because you're temporarily unable to handle your finances. When you get better, you have the right to step back in. So we have 3 locations that we can meet with you at. We have an office in Denton, an office in Aubrey, and an office in Bartonville. I have several books that you might want a copy of. One is the one that this speech is based on. It's the Who Gets Your Stuff When You Die. As we're going through the speech, there's actually a chapter on the book that covers each of the slides that we're going to go through. I also have individual speeches that cover the topics on each of the slides. So if you're interested in more information from this speech, you can either ask our office for a free copy of the book, or you can go online and look at the other videos that we have. Another book you might be interested in is What Your Spouse Should Know If Something Happens to You. This is one to make sure that your spouse knows where things are, how to find things. Because in marriages, the longer you're married, the more it is that one of you does certain things, the other does others, and you may not both have the knowledge as to where things are. I'm working on another version of this, which is What Your Family Should Know If Something Happens to You. We should be publishing that within the next 3 months. And then the next book I have is Finding Strength in the Face of Alzheimer's. And I wrote this one because I had 2 clients who were taking care of their husbands with Alzheimer's. And both of these wives actually passed away before their husbands because they were so exhausted from caregiving. So one of the most important messages of the book is to be sure and take care of yourself if you're taking care of somebody else. So distributing your stuff, choosing who's you're going to get your stuff and helping them keep it. So in order to design a plan for you, we're going to ask you some nosy questions about your family. And the reason why we ask those questions is we need to get to know the people that you're leaving money to in a way that we know whether they're going to be responsible when you give them money. Are they responsible with the money they have now? Will they be responsible with what they receive from you? And also, is there anybody that would influence them to spend the money in a way that you would not like? And so we're going to ask questions about the people you're leaving it to, their spouses, their kids, the families, and we're looking for anything that makes it where we need to customize what we're putting together. Handle with care stuff. What to do if a beneficiary is disabled. So if you have a beneficiary with a disability and you leave that beneficiary more than $2,000, you will throw them off of whatever benefits they're receiving. So if you were to have a grandchild who has a disability and that grandchild is actually old enough to be living in a group home and Medicaid is paying for that grandchild's medical expenses, and you leave them $10,000 or you set up a college savings plan for $10,000, then that actually throws them off Medicaid. It also makes it where they can no longer live in the group home until that money is spent. So there's a much better way to leave money to that person. You can leave it to them in either a supplemental needs trust or a special needs trust. They're the same thing, just 2 different titles. And that trust can say that that grandson, that money can be spent for anything he needs, as long as it doesn't pay for things that the government is already paying for. And that way the money's available for him, able to take care of him. And as I said a minute ago, I've got an entire speech on these. So there's an entire speech on how to protect somebody with a disability if you're leaving them money. So the next one is Stuff Happens. Smart moves if you or your spouse are diagnosed with Alzheimer's or dementia. So most of the time when somebody gets a diagnosis like this, you go through the same stages of grief you would go through if somebody passed away. And one of the first stages of grief is denial. So in the initial stages, you're going to want to believe this isn't happening to you, or maybe it's not going to be that bad. But one of the important things with estate planning, remember I started at the beginning by telling you have more control the sooner you plan. So when you first get news like this, if you come in, we can set up a plan that specifies who's in charge, and this time it could be you because you're still able to make your own decisions. You could then name people who are successor people to be in charge in the event you're not able to be in charge. And if you have any of those dysfunctional people in your family, you can actually make sure that they never ever get to be in charge of you or your money. If you wait until you can't remember how to spell your own name, don't know your family, we're not going to be able to do that much planning for you. We might be able to do planning for people who are leaving you money, and there are some protections that we can do. But you have a lot more control and a lot more options if you plan earlier. So incapacity stuff, what if you're out of it? So all of us, as I said earlier, we all know we're going to die someday. We hope it's way far away and we hope it's quick and painless, but we don't all know we're going to become incompetent. And actually we hope that it doesn't happen. But it's better to have a plan in place that protects just in case it happens than to ignore it as a problem or a thing to think about. So real quick, let me tell you the difference between a will and a trust. So wills and trusts both specify who gets your stuff when you die. The distinction is, does somebody have to go to court in order to be able to have that happen? So if you were to choose to do a will and you pass away in the state of Texas and the will has all the language that it needs to have, so it's a well drawn up will, then probate in Texas takes about 4 to 6 months, costs between $4,000 and $6,000. If you have a will that was drawn up in another state that doesn't have the right language, or occasionally there are ones that are drawn up even in the state of Texas that the attorney doesn't put the right language in there, you end up going through what they call dependent administration, and that probate can take over a year and cost $15,000 to $20,000. So that's one of the reasons why if you've moved here from out of state, it's worth getting your will reviewed. A lot of our clients will set up a trust instead. The trust can still specify who gets your stuff when you die. One of the advantages to a trust, if you've gotten all your assets in the name of the trust, is nobody has to go to court. So if you pass away and all your assets are owned by the trust, then there won't be any need for court involvement, meaning the people you've named to step in can step in right away. It also has the advantage of, in the event you become incompetent, the people you've named in the trust can step in without having to go to court. It also makes it where people, if you have dysfunctional people in your life that might try to become in charge, they're not listed as people who are able to take control of your trust or have part of your assets. If you don't have a trust in place and you become incompetent, what happens is the court has to appoint somebody to be in charge of you. And what they look at first is they look at family members. So the family members are going to be the first in line in order to do that. And if you have, for instance, 4 kids, all 4 kids have equal rights to be in charge of you. And it may be a matter of that they fight in court over who's in charge, and it would be much better if you have a specific person named to do that. And if we do it through a trust, then we're not having to have court involvement to get that done. So healthcare stuff. Who's going to make your healthcare decisions for you if you can't? So if you were in the hospital unconscious and there needs to be a decision regarding medication or surgery, who do you trust to make those decisions? Most of my clients appoint their most soft-hearted child in order to make these decisions, but a lot of times it's really hard on that person to make those decisions. So one of the things you need to think through is, will they make the decisions the way you want them to, and are they going to be able to do it when the time comes? I talk to mothers and daughters all the time where mom will say, I don't want to be kept alive on machines if I'm in the hospital. And the daughter will say, Mom, I'm going to put you on every machine possible. I can't imagine letting you go. Now, who do you think mom puts in charge? It's that daughter every time. But what mom thinks is, daughter heard me. I said I didn't want to be put on machines, so my daughter's going to follow my wishes. What the daughter thinks is, mom wouldn't have put me in charge if she didn't agree with me as to what needs to happen. And if you ever get put in the position of making healthcare decisions for somebody else, you're supposed to step in their shoes and make the decisions the way they would want them made. So you're not making it based on what you would want in the situation, it's what you think they would want in the situation. So that brings up another thing that's kind of hard for people to do, is to actually talk about that ahead of time. So one of the biggest favors you can do for the people you're asking to make these decisions is to have the hard conversation about when you want to be on life support and when you don't. Because most of my clients, when I ask them if they want to be kept alive on machines, if they have a terminal condition, meaning they have less than 6 months to live, even if they get put on machines, most of my clients tell me no. But everybody means something different. And so if you explore it a little more, you may find that some people are okay if they can, as long as they can communicate, spend time with family, they're happy, they'll be happy to be kept alive. There are some people, if they never fully get to go home, they never get to be independent again, that they're going to be very frustrated with the care. And so it's a matter of talking with people. And really, when you talk to people about where your line is and what's important to you, it's more for them than you. Because if you think about it, at the point where they're making decisions, you're going to be unconscious. But one of the things you can do is give them the peace of mind that they're following what you actually asked them to do. Because I talk to children all the time that when they've had to let mom or dad go, they second guess whether mom or dad really would have wanted more care, if something else would have helped, and if they really did the right thing. I also hear that among spouses. So if you give your kids the peace of mind that they know that they're following what you want, then they're going to be more likely to feel peace of mind regarding that. So the next one is HIPAA. So knowing how the privacy laws affect your plan. So HIPAA is the law they passed in 2001. The reason why they passed it is doctors and hospitals were actually selling medical information. So in order to keep them from doing that, they actually enacted a law that said that they would pay huge fines or go to jail if they released your medical information without permission. So in order for a doctor or a hospital to give medical information to the people that are making decisions for you, they need a list of people that they're authorized to give that information to. The hard thing is they didn't come up with a standard form. So every doctor, every hospital talked to their attorney. Their attorney designed a form. They were told if this form is signed that they can't get sued. So the doctor or hospital is going to want their specific form signed. What we do for our clients is we prepare a privacy release. We have lists on there the people they want to have access to their medical information. And then we also add language to that and their medical power of attorney and their financial power of attorney that allows those people to sign whatever the doctor or hospital wants signed. And that we've been successful in using that for a long time. We also provide our clients with an emergency document card. It's a card they carry in their wallet. That way, if they're in the hospital unconscious, the hospital has access to their healthcare power of attorney, their directive, whether they want to be kept alive on machines, and also the privacy authorization, who can check on them in the hospital, who can look at their medical records. So the next one is who needs benefits. So this is just in case you or a family member need either Medicaid or veterans benefits. There's an entire 45-minute speech on my website regarding this. If you want a lot of detail on it, you'll need to go and look at that. But let me just give you a little bit about it. We attorneys call this issue spotting. So it's enough information for you to know whether you have an issue or a reason to have a conversation around it. So a lot of my clients have family land. So they have land that's been in the family for a long time. Medicaid allows you, if you go on Medicaid, to keep a house and land around $600,000. Veterans benefits allow you to have a house and 2 acres. So if you have property worth more than that, or more than 2 acres if you're doing VA benefits, then it might be worth doing planning ahead of time. So the planning ahead of time is we set up an irrevocable and unchangeable trust. It has to be set up 5 years before it's needed. We put the assets into it, and then that allows those assets to be protected in case you need care. The other thing that some of my clients do with this trust is they may put their house in it even if it's not over this value. So that way, if they ever have to go to the nursing home, the house can be sold during their lifetime and the money can be used for their care. So for Medicaid, the type that we help with is for when somebody needs to go into skilled nursing, meaning they need 24-hour nursing care. Medicaid will pay for that as long as you meet certain asset and income requirements. Part of why we do the 5-year planning is to get your assets down below those numbers. VA benefits, the type we help with, is called aid and attendance. It's also called housebound. These are the ones that are a pension. In order to qualify for the pension, you have to have served in the military 90 days active duty, 1 day during a defined period of war. You also have to have a need for care. And for a veteran, they give you about $2,000 a month. For a spouse of a veteran, it's around $1,600, and for a widow of a veteran, it's around $1,100, which is not enough to care for you full time, but it is enough to supplement with your other income, and a lot of times it allows the caregiver a break. But like I said, if you want more information, you can get more information from the longer seminar on that one. So protecting stuff after it's theirs. So I told you I'm going to ask you nosy questions about your beneficiaries. So one of the bright line things I'm looking for on each beneficiary is, are they responsible enough to manage their own money? So for the ones that are responsible enough to manage their own money, that you're going to put in charge of their own portion of the trust, most of my clients want to still protect it just in case those beneficiaries get divorced or get sued or have creditor problems. And for a lot of my clients, one of the most important things is to make sure what they leave to their kids actually makes it down to the grandchildren. Because if you leave money to your daughter and she passes away, she most likely is going to leave it to her husband. And even if you like him and you're okay with him inheriting it, you're probably going to be bothered if he passes away and leaves it to a new wife instead of to those grandkids. So there is a way we can set it up where we can leave the money to your daughter. She can use it for anything she needs, but on her death it has to go to the grandkids. I do have a few clients that actually do want to include the son-in-law or daughter-in-law, and we can do that, but we can always then make sure that it circles back and goes to the grandchildren. Now for your irresponsible beneficiaries, we're going to talk about putting somebody else in charge. Now I talked to you at the beginning about family harmony. So if you put one kid in charge of the other's money, what is that going to do to their relationship? And so it at least needs to be thought through. Maybe a corporate trustee or an independent party being in charge would be better. So that way we don't have the strain within the family. So important stuff, how to communicate your values to the next generation. Most inheritances are treated exactly like lottery winnings, which means they're blown within 1 year. I had a client many years ago. She inherited $800,000 from her mother. Prior to inheriting it, I would have told you that she would be able to handle inheriting money and not blow it within a year. After she inherited the $800,000, her and her husband were in their late 40s. They both decided they had more money than they could ever need for their lifetime, and so they both quit their jobs. They both then put their kids into private schools, started taking expensive vacations, bought a bigger house. By the next year, they had actually spent every dime of the $800,000, plus they had a dramatically more expensive lifestyle. After the inheritance, she was actually more broke a year later. So when we're looking at beneficiaries, we need to think through, can they handle inheriting money? So think about, if you're going to leave money to a grandchild who's in their 20s, are they going to continue to work? Or are they going to just not work until they've spent all the money and then not have that money to use for other things? So a lot of my clients will actually match earnings if they're leaving something to somebody in their 20s, so that way they have an incentive to be gainfully employed. Our clients actually give more to charities than most other estate planning attorneys, and the reason why is kind of simple. It's that I actually just ask you the question. So in our planning, one of the questions I'll ask you is there a charity you care about? Do you want to leave money to it? Do you want to leave money to it if your whole family went away? Would you want to leave money to charities? I mentioned that to another attorney at a conference one time, and they said, we don't ask our clients that because that's too invasive, that's too personal. But if you think about it, I'm already asking you quite a few nosy questions. Whether you care about charities or not should be one of those. And if you don't, that's fine. Other thing is, I have a lot of clients that want to educate the next generation. So recently I set up a trust for a lady who wanted to make sure her nieces and nephews and great nieces and nephews had the ability to go to either trade school or college. So it's a pool of money that can be used for either one of those. But if you're going to do that, I'm going to tell you two stories. One is a lady I went to law school with. Her name was Shawn, and at the time I met Shawn, she had actually been going to school 20 years after high school. And the reason why she was doing that is her grandfather had set up a trust, and his only requirement in it is that she had to go to school full time, she had to make good grades, and she had to be seeking a degree she didn't already have. And so when we were getting ready to graduate, we were all looking for jobs, and Shawn was actually trying to figure out what her next degree was going to be. Now, I didn't keep track of her after law school, but I know when she left law school, she went and got a master's degree in law, which was another 2 years. And I almost bet that she was continuing to find whatever her next degree was. Now, the grandfather may have loved that. He may have liked the idea of education, loved the fact that she was getting educated, but probably my guess is that he expected her to be gainfully employed at some time. So I told this at a speech a while back. Actually, it's been a number of years ago. And I had a client come in and they said, "You want to hear a worse story?" And I said, "Sure." And they said, "Our grandson, the other set of grandparents, set up an education trust. All the grandson has to do is make good grades and not already have a degree." And they said he is now, for the last 5 years, been taking one course per semester. He takes the easiest class possible. He makes an A in it, and all of his expenses are paid. So he's pretty much playing video games, taking this one class. And he actually now has been doing it long enough that he has to be somewhat careful that he doesn't accidentally get a degree. So another important thing to think about education is if you had a pool of money for a number of nieces and nephews, or great nieces and nephews, are you okay with one of them spending all the money? So if the first one to go to school goes to an expensive school and spends all the money, then maybe the others won't have an opportunity to use the money for school. So that's the other thing that I explore with people is, do you want to require certain grades? Do you want to make sure that there is some money available for everybody within the pool? And do you, as far as housing, do you want to do the most expensive housing or what they may be equivalent to a dorm? Just kind of looking through all the details with it, thinking through it. So retirement plans. So your retirement plans are most likely the largest asset you're going to leave behind. And the reason why I know that is most of my clients complain about having to take those required minimum distributions every year. And so you're not going to want to do that because you're not going to want to pay income taxes on it. So for most of my clients, that's the money that they spend last. Now, real quick, let me give you a tip if it does bother you to take those required minimum distributions. If you're giving money to any charity, there's a way where you can have that distribution go directly to the charity. And the advantage to you is it actually reduces the amount you pay in tax. So if you instead have the money come into you, you pay income tax on it, and then you get a tax deduction for going to the charity, you actually get less of a deduction than if it wasn't ever your income at all. So that's something to explore with your financial advisor if you are giving money to a charity. But the other thing that I do for my clients regarding retirement plans is we talk through how they want to leave them to other people. So if you leave your retirement plans to your spouse, do you want to make sure your spouse leaves it to the kids? And there's a way you can leave it to your spouse in a way they still get to take it out the same way they would if they got it outright, but we can put a trust on it that's a protective wrapper that makes sure that it goes to the kids on the second death. And then also, once it goes to the children, we can add language that protects against divorce, creditors, and lawsuits. Now, the Secure Act, which was passed in 2020, makes it where those distributions are over a 10-year period for most people. There's a few exceptions. But if you have a beneficiary who's disabled, and then for this qualification, it's actually disabled at the time they're receiving the retirement plan. So at the time you pass away, if this person's disabled, there is a way that that person can take it out slowly over their lifetime. And we've got to make sure that we have a trust wrapper around it so it doesn't disqualify them from public benefits. So if you have a disabled beneficiary, it's very important you work with an attorney that knows what they're doing regarding retirement plans. There's another video specifically on retirement plan trusts. If you're interested in more information, I recommend you watch that. So finding stuff and organizing stuff. You're going to know where to look, they won't. Do you hide money anywhere? If so, you need to write it down somewhere. I can tell you lots of stories of different places people hide their money. I actually had a lady in one of my seminars during the question and answer session. She raised her hand and she had said, "I had $20,000 in silver buried in my backyard and I can't remember where it is." There was actually another man at the seminar who actually offered, he had a metal detector, he offered to go to her backyard and help her find it. But you really shouldn't be disclosing to people you have money hidden in the backyard or in the house. But the question is, how would her family have known that was there? She wasn't even exactly sure where it was. So if you have stuff like that, write it down. Also, if you have accounts that you don't regularly use, it's worth having a list of those so people know where to find them. And if you have any paid up life insurance policies, meaning you no longer have to pay premiums, you need to give information regarding that so that people know to make claims. They actually say that 5% of life insurance policies that mature, meaning somebody passed away, actually go unclaimed. And the reason why they go unclaimed is because the family doesn't know they exist. Because you don't owe premiums, they're not going to receive a premium notice, so they're just not going to even know that those are out there. So in second marriages, you've got to be careful to make sure that your kids don't get disinherited. If you leave everything outright to your spouse, you have a risk that they're going to leave it to their kids instead of your kids. And I can tell you that that happens a lot of the times. There is a way we can structure your documents where you leave assets, you take care of your spouse can spend it on anything they need or want. The only restriction they have is on their death. It has to go to the people you've agreed to have it go to. Now, I used to only talk to people about this in second marriages until I had one of my fairy tale families, and I don't think I've said this yet on this speech, but there's dysfunctional families, and then the families where everybody gets along, I call them fairy tale families. Now, I have a few that actually will hold up under stress, but a lot of times with fairy tale families, when you put stress on the family, things don't quite go how they should. So in this particular situation, it was a husband and wife that had actually been married for 65 years. Wife got Alzheimer's, and they hired a caregiver for her. They happened to hire his high school sweetheart. So very, very nice lady, took care of the wife who had Alzheimer's, also, of course, took care of the husband during that period of time. So then the wife passes away. The husband then marries his high school sweetheart, and they're a lovely, wonderful couple. Now, the original couple actually had 4 kids, a whole bunch of grandkids, a whole bunch of great-grandkids. So after the wife passed away, he's married his high school sweetheart. They've been married for a number of years. They come into me to redo his will. And do you know who he left everything to? The new wife. And his logic was pretty good. His 4 kids, of course, at that point are in their 60s, 50s and 60s. They're fully grown. They have kids and grandkids of their own. They don't necessarily need the money. His new wife did need the money, and so he left everything to her. And I started thinking about it. James and I have been married 36 years. We have 2 boys together. When I pass away, I want James to be able to spend everything we have, do whatever he wants to with it, except I want whatever's left of what I left him to go to our boys. So I want to make sure something goes to our children. So we can set up the documents and how I have mine set up. James and I both leave all the money to each other. The surviving spouse can spend it on anything we need or want. The only restriction is on the death of the second one. It has to go to the 2 boys. So in a meeting, we're going to talk about that. Now, it's up to you. If you want to leave it outright to your spouse, you're not concerned about them remarrying and leaving it to somebody else, we can do that. Or we can put this protection on it to make sure that your kids aren't disinherited. So sentimental stuff, saving your family conflict and confusion over the personal property. Now, when I first started giving this speech 15 years ago, your kids wanted your stuff. Nowadays, I hear more and more that the kids do not want the stuff. But I can almost guarantee you have 1 or 2 items that they're going to argue over. So earlier this year, I was meeting with a mother and her 4 kids, and I think they would have fit in the category of one of the fairy tale families. In the hour and a half that we met together, they got along beautifully. They were joking and laughing and just really good, warm feelings among them. Towards the end of the meeting, we talked about personal property, and they all laughed and joked that they pretty much didn't want anything. And then the daughter said, I only want 1 item to remember you by. And the 1 item is the painting above the mantel in the living room. And the mother said, well, sure, you can have that. And the other 3 kids said that was the only thing we wanted. And after that, there was a tension in the room that wasn't there before. So it's important to talk through it and to think through what people want as far as things to remember you by. Also, if there's a history behind it or a story behind it, if you don't write it down or do a video of it or an audio tape of it or something, that history may be lost altogether. I hear from daughters all the time. When mom passes away, mom told me the story behind this painting to the point I was sick of her telling it. But now that she's gone, I can't quite remember. So till we meet again, has it been over 3 years since the attorney who drafted your plan created it? I hear from people all the time that they don't even remember the name of the attorney who created their plan. They have no idea what's in it. And part of it is talking about estate planning, as I talked about towards the beginning, is kind of depressing. So you're going to want to put it on the shelf and forget about it. But it's important that it works when you actually need it. So one of the reasons why we meet every 3 years is to make sure that there's not any adjustments that need to be made to the plan based on things that have happened in your life or in the people you've named to be in charge or the people that are receiving money's lives. Also, we can talk about whether there's been any law changes that make it where we need to adjust things. It also maintains our relationship. So that way we have a relationship and you trust me enough to tell me about things that I need to know to help you with the plan. Now, I told you in the beginning, we do both estate planning and elder law. So in the last couple of years, I have a couple times had one of these meetings, had a wonderful meeting with the people. We've gone over the plan. They tell me there's nothing that's changed, nothing needs to be adjusted. And as we're walking out, either the husband or wife taps me on the arm and says, by the way, one of them said, I've been diagnosed with Alzheimer's. The other said, my spouse has been diagnosed with Alzheimer's. Does that matter? And the answer, of course, is yes. So I call them back in and we sit down and we have a conversation about how do we protect assets just in case the healthy spouse passes away first and the one with Alzheimer's or dementia needs to be taken care of. But part of what I'm telling you is that because we've met over a number of years, both of these clients, we had enough of a relationship where they trusted me enough to tell me about it so that we could work on it. So if it's been over 3 years since you've had your plan updated and you're one of our clients, call and schedule a time. We don't charge for that meeting. We do charge if we make changes, but we don't charge to do those regular check-in meetings every 3 years. If you have a plan that's designed by somebody else and it's been more than 3 years, it's worth looking at. I have met with many people over the years that when I tell them what their will or trust says, it's totally different than what they thought it said. Other important thing that we're emphasizing more and more with our clients is we can draw up the most beautiful trust ever, has absolutely perfect language in it, does exactly what you want it to do. If you fail to put your assets in it, it's not going to work. So one of the advantages to the 3-year meeting is it's another time for us to get together to make sure that your plan is going to work when it's actually needed. So where do you go from here? If you're like most people, you're going to end up procrastinating. I actually had a man come in, I guess it's been a few months ago. He had been to one of my seminars before I had the book, so more than 15 years ago. Back then I used to hand out a blue folder, and in that folder I had brochures, and he had kept the folder. He knew he wanted to use our firm for estate planning, but he didn't feel quite like he needed it yet, so he was going to keep the folder for later. So he now is facing some pretty major surgery, needs his will or trust done urgently. And so then he comes in to get it done. And the hard part is if we're trying to do it urgently, quickly, we're not going to have as much time for him to think through what he wants to do. We also don't have as much time to get the documents ready. And so it would have been much better if he had actually put something together before and then we could be adjusting it at this time. So the sooner you plan, the more control you can maintain. And also, we all don't know what might happen in the future about whether we'll have the ability to make the decisions in the future. We would love to meet with you and get to know your family and put together a plan that's customized to your unique family situation. We look forward to meeting with you.